Hello guys, and welcome to another episode of my lecture. On today's episode, we'll be discussing about the Nigerian court's disposition to the provisions of Section 4 of 2011 Evidence Act in Nigeria. And with that, we go straight to the notes. Now, Section 4 of the Evidence Act was considered in the Supreme Court case of ISHOLA versus the state. Now, in this case, it was alleged that the appellant had shot and killed the deceased in the night, but under the moonlight. Evidence was laid that before this incident, the appellant had been having problems with the villagers, including the deceased, at times reporting them to the police station. It was found by the learned judge on a query that the appellant was improperly identified, that because of the previous conflict, the appellant must be a well-known person to the villagers, and especially the deceased and members of his household. Appellant was therefore convicted of murder. Now, evidence is necessarily admissible as to acts which are inextricably moved up with the history of a criminal act itself as to form part of one chain of relevant circumstances, and so could not be excluded in the presentation of the case without the evidence being thereby rendered intelligible. Do you understand that? The court here is saying that where you are trying to prove something, if there are other acts in other days or other weeks or other months that can shed light to this particular circumstance, those acts would be relevant to the fact in issue. That's the case of ISHOLA versus the state. So this is what in fact is the authority on Section 4. Do you understand? So you don't necessarily only need to have Section 4 when it is, pari passu, going in line with strict contemporaneous, or when it is, even if it is a month before. So far, it can shed more light on this particular happening in such a way that that act is not rendered intelligible, which means that there is no break in the nexus between the act a month ago and this act. Then yes, you can have it. Do you understand? So for example, one boy and one girl, they like to see each other, and then the father of the girl has always been telling the boy, I don't want to see you, my daughter, I don't want to see you, my daughter, and things like that. But the boy is not, obviously, love has a strong way of holding a man. So now, on this particular day, in April, the father went to the boy's house, told the boy, I don't want to see you, my daughter, again and again and again. Just like that. Now, in September, the daughter got pregnant. The question is, can the fact that the father went to the boy's house in April be admissible in evidence where something happens, probably there is abortion, and then the father is trying to prove that the boy was the one who forced the girl to do the abortion, and so the boy has been charged? So now, can that particular talk of April be admissible in an incident of September? Do you understand what I'm saying? According to what the Supreme Court in ISHOLA versus the state is saying, if it forms part of the same transaction, then yes. Because the reason he went to the boy's house to say, I don't want to see you, my daughter, is because he doesn't want him to have a romantic relationship with her. But let us say that what happened to her is that she was killed, and he was not there when she was killed, or there was nothing that can connect him to her. But then you are not coming to meet and say, I went to meet him that time that he should leave my daughter. It's because he did not leave my daughter that my daughter died. I mean, that becomes, the court will start saying, brother, chill. Do you understand? But because it is a sexual thing in question here where she got pregnant and then she aborted, and now there is a trial on that, that might turn that into evidence properly, be relevant to the fact in issue. So, thus, in the case of murder, evidence is admissible to 1. Show prior acts by the accused upon the murdered person. 2. Menace is offered to him by the accused or to show conversely. 3. The irritating behavior of the deceased to the accused. 4. The relationship of the murdered man to his assailant so far they may reasonably be treated as explanatory of the conduct of the person charged with a crime. This stated above would be admitted as proof of integral part of the history of the alleged crime for which the accused is on trial. So you see, there are 4 things that you also have to look, but note that the judge was saying it in the context of murder trials, but that doesn't mean that it has to be. Logically speaking, you should understand what the judge is trying to say here. Where there are acts that can explain what has happened, even if the act is 1 year ago or whatever. But the thing is that it must not be that act that you are trying to bring has been rendered intelligible by something. If something renders it intelligible, then it's not admissible. Do you understand? So let us talk about the boy and the girl now, for example, that I stated earlier. I told you that the father went to meet him in April, the girl got pregnant in September. Now imagine after the father went to meet him in April and the girl got pregnant in September, there are other boys that the girl has had romantic relationship with. That's number one. Number two, after that time, the boy traveled out of the country to England. In fact, the next day, the boy traveled to England. Now, yes, until I introduced this set of facts, that fact made sense, right? Now that I've introduced this fact, does it still make sense that you should admit that into evidence? No, now, because there are other facts that have rendered that fact intelligible. It doesn't make sense to admit that you went to go and meet him when he wasn't even in Nigeria at the time of the act. Do you understand? So yes, that's what the judge is saying. So you have to look at the relationship, the history of this particular criminal act in question before you come to a conclusion that it is important. Look at the history, look at the nexus. If the nexus is not broken, if the history still is intelligible in the light of this particular incident, then yes, it forms parts of section 4. I wouldn't say res gestae, because res gestae would then have to be in context of either strict or sufficient contemporaneous rule of the common law. So I would say in context of section 4 of our Evidence Act. So we continue to note the dictum clearly means that the provision of section 4 of the Evidence Act are superior to the exclusionary provision of proviso A of section 1 insofar as such connected act, though remote, are not rendered intelligible by such circumstance. So what we are saying here is that you must read that proviso under section 1 of the Evidence Act closely with section 4. Do you understand? Section 4 seems to open it up a little, but it shouldn't be opened up so much so that particular act, then you can't bring a nexus, or then that act is intelligible. It doesn't make any sense anymore. Do you understand? Section 4 helps us open what you can bring into evidence. It is not even, in fact, it necessarily doesn't even need to be a statement, as we could have seen in other cases. But it doesn't necessarily, it could be an act. The father going to his house to knock at his door, we wasn't around that day. That act alone shows that there is something. It can be admitted into evidence. Do you understand? Because they didn't say that statement. When you are reading the provisions of section 4, it didn't tell us statements. It tells us facts. Do you understand that the fact that the father went to his house, even though he didn't say a word because the person wasn't around, is a fact? Do you understand that? So we then move on to our next case. That's the case of Anthony ISIBOR versus the state. PW6 was robbed of his vehicle with registration number OY6898. The next day, the same vehicle was used to rob PW4, also of his own car. It was argued that the evidence of PW6 was unnecessarily prejudiced to the accused. The Court of Appeal held that the evidence of PW6 was relevant under the provisions of section 4 and section 5 of the Evidence Act to enable him extricate himself that he wasn't a member of the robbery gang that robbed PW4. Now, how is this relevant? Now, PW6, his car was robbed. They used his car to rob another person, PW4, who came to testify. Now, the defense counsel stood up and raised objection against the testimony of PW6, saying that it is unnecessary. Now, that's where it forms part of res gestae, because I told you that it is not only statements that form part of res gestae or part of evidence that can be admitted under section 4. In this case, it is an act. The act where PW6 was robbed of his car the day before they robbed PW4 of his car. How is that relevant? Because it shows history. It shows pattern. We can see PW6 car in the robbery attack against PW4. It raised the assumption that PW6 is a gang member. Not just that. If he's not a gang member, then PW6 come and tell us how he was robbed, how they took his car, and how the whole thing can give us more information on the robbery of PW4. Do you understand? Because the reason the defense raised that objection is because the robbery of PW6 wasn't on the charge sheet. What was on the charge sheet was the robbery of PW4. So therefore, PW6 should not come to testify. But the court held no. PW6 has come to testify on two things. First of all, to show that he's not a gang member. Because you use your car to rob someone else and you kept quiet. No, it means something is going on. But then, now, not just that. The fact that it helps us show history of robbery. Do you understand that? It's part of the same transaction. The car being what they stole from PW6 to use to rob PW4 is part of the same transaction we are talking about. So it is admissible under the res gestae doctrine. Do you understand that? So yes, that is where we end our lecture on res gestae. But before I end it finally, let me get to my conclusion. It is safe to say that Section 4 of the Evidence Act is similar in scope to the common law doctrine of res gestae, as it is couched in a way as to accommodate both the strict and the sufficient contemporaneous rule. So there should be no need for the doctrine to be applied instead of Section 4 of the Evidence Act. It should be noted that the Evidence Act did away with Section 5A of the old Evidence Act, and thus the courts are no longer allowed to admit any other evidence not provided for or authorized by the Evidence Act. The common law rules and cases are only of persuasive effect. Yes, with that, we end our lecture on res gestae. And our next series of lectures will be on Section 5, Section 6, Section 7, Section 8, Section 9, Section 10, Section 11, Section 12 of the Evidence Act. Trust me, it's going to be a very fun ride and very interesting. I'll see you in my next series of lectures.